being compliant with that rule is going to stop identity thieves from basically stealing cars from you. And I've talked to mid-sized dealers that lose over $1 million a year to identity theft. As most of you know, the contract's going to come back on you as the dealer, and you're stuck with the bad deal when the finance company kicks it back to you because there was an identity thief involved. So that to me is sort of low-hanging fruits or something that dealers could probably tighten up easily and save them money today.
Welcome to the Car Dealership Guy podcast. Today, my guest is Brad Miller. Brad was the former chief regulatory counsel at NADA and currently the head of legal at ComplyAuto, a compliance solution company serving car dealers. We dive deep into the most costly compliance mistakes dealers are making, plus the top 3 sleeper risks within dealerships. Let's get into it.
A big thank you to our sponsors for making today's episode possible: Open Lane, Car Dealership Guy News, and ComplyAuto. And now let's get into the show.
You know, compliance is like one of those topics where if you told me a couple years back, like, hey, Yossi, you'd be excited to speak about that, I'm just being honest with you. Like, I would have said like 0 chance. Take me to the dealership outages, right? With CDK, then there was some impact from CrowdStrike. We saw kind of multiple companies in a span of maybe like a month and a half. I'm starting like very big picture, but do you think that this was like a harbinger moment for the industry where like things will materially change for the customer, for the dealer? Or is this like, hey, it's another bump along the road? Will this and has this like changed our industry forever, and in what ways?
Dealers are very unique in all of the American economy in the sense they are probably one of the most highly regulated small businesses that are out there. I mean, you think about, whether it's environment, health and safety issues in the back end, in the body shop, and the service department, because of all the chemicals and the heavy equipment and the lifts. And then you also have, the employment issues and the interface with the OEMs. And because of what dealers do in the front end, very sensitive financial information, credit applications, assisting consumers with financing and leasing vehicles, they're regulated like banks. I mean, really, I've told dealers for many years, you're sort of swimming in the deep end of the pool, and you can't have your floaties on, right? I mean, the dealers have to get serious about what's happening. And look, they're trying to do their daily business. I think that what this really will mean is they need more and more dealers will see knowing what's going on with their systems, having some technical capabilities internally, and getting the right people to work with externally is going to be a core competency of being a dealer, right? I mean, you can't go to other, dealers are financial institutions under federal law. We can talk about why that is and how that's sort of come about. But the reality is they're the regulated entities. They're the only regulated entity in the auto space, right? It's not the OEM. It's not the vendor in most cases that is directly regulated. It's the dealer. So the dealer has all these obligations on them, and they frankly need help, right? And so it's been a struggle for a number of years, sort of raising the awareness of these issues. Again, I hope at the end of the day, the CDK issue and some of these other issues result in no exposure of customer data. I hope the damages are minimized, and I hope for the best outcome. But the reality is, when you see your entire operation go down, in many cases for days, if not weeks, that is a wake-up call.
Give us a quick overview of what you do today. I just want to set the table for the conversation and all these different areas within automotive we're going to touch on. Just explain that you're a ComplyAuto. Can you just give us an overview? Like, what does ComplyAuto do? What do you do within ComplyAuto? Just give us the high level.
Absolutely. I'm the head of legal at ComplyAuto, so I've been brought in as the main lawyer, director of compliance and regulatory issues at ComplyAuto. ComplyAuto is a software company, so we provide software and services to dealers to help them meet their compliance obligations in several specific areas today: privacy and data security, safety, and also in some sort of advertising and F&I tools that are very powerful as well as workforce and some other areas like some state-specific training issues. But it's a broad suite of training software, compliance software for dealers. I've been at NADA for 16 years. I'll tell you, I had been in many meetings with dealers, oftentimes many of the largest dealers in the country, most sophisticated, very smart people who are talking about data issues, talking about privacy and data security, and just needed help. They clearly needed help. And we did what we could from NADA's perspective to help them. And NADA does a great job in many ways. But I looked around and said, I think they need some more specific real world actual in the store help. And I knew the folks at ComplyAuto. I knew what a great job they did, what a great product they had. And so, I joined them a couple months ago to sort of help them get these products in the hands of dealers, right? The theory is leveraging technology to help dealers address these very complicated obligations they have under the law. And it's really been, it's a 3-year-old company, and it's gone from, nothing to 10,000 dealers very quickly because the product's good and because the need is huge.
Okay, that's helpful. Now, I want to kind of go step by step here. We have, I want to touch on cybersecurity, then I want to go to CARS rule and FTC, and then we can keep going from there. We can pick one regulatory agency at a time. All right, so let's just start with, you mentioned to me before the call that there's some really like sort of breaking news, fresh news regarding the CDK situation, dealership outages. Can you share that with us?
Absolutely. So for those of you who've been sort of under a rock, on June 19th, there was what was called a cyber incident at CDK, which was widespread and took a lot of dealers down in terms of their other online operations. There have been several updates from CDK, and there was one issue just yesterday. So there is some breaking news in this area. Obviously, we put out information on all the updates to date to give you some background. The latest is the following. Is that the CDK issued an update saying a few things that are important. One is they reiterated that as of today, they have not determined that any.
I was just going to say, by the airing of this podcast, it'll be a couple of days ago. So
a couple of days ago, okay. So at this most recent
in the last week,
in the last week, in the most recent notice that we're aware of, CDK announced that they have their investigation is continuing, but they still don't have any indication that what's called PII, or personally identifiable information, was involved. And that's a very important threshold issue that dealers have to understand, because the legal obligations that flow to dealers change tremendously if whatever happened at CDK involved information, right? If someone got Brad Miller's information, my address, my social, whatever information they had at the dealership, that means that certain other obligations come into effect for dealers. Okay, so as of today, they still say that no indication is being involved, but they also have agreed to do two things, because two of the important things that arise for dealers in a breach situation is you got to notify the FTC on a federal level, and then you have to notify the consumers that were affected under state law. So there's federal obligations, state obligations. CDK had already announced that they were going to go ahead and notify the FTC on behalf of all the dealers, right? So that was they were reiterating that they were going to do that. Then one bit of news was they shared the fact that they actually have filed something, and it was within the 30-day time frame with the FTC. So that's important. But the second piece is they also agreed that they would handle any state data breach obligations in the same way. So that's news. And that's important. And that's very, it's a great thing that they've stepped up to say that they're going to do that. I don't know that it ends the inquiry for me if I'm an in-house lawyer at a dealership, but it is a good thing and it is news. So still no indication PII was involved, but they're stepping up on both the federal and the state notice level to help dealers with those notice obligations. So that is breaking news and something that dealers should know about.
All right. So Brad, tell us more. Let's dig deeper into the CDK and CrowdStrike outages. Like, I would talk to me like bigger picture implications. Where does this go from here?
And, we haven't talked much about CrowdStrike. Just to be clear, thankfully, CrowdStrike did not affect dealers directly. I mean, some dealers were affected, to be clear, but it wasn't nearly as widespread in the dealer world as the CDK incident. And remember,
CrowdStrike affected many vendors that work with dealers.
A lot of vendors, that's right. And of course, the worldwide economy, good grief, just so people understand, the CDK issue was clearly, we don't have details yet, but pretty clearly it was a bad guy that got into the CDK system and extracted a ransom payment, the classic sort of hack/ransomware. CrowdStrike was a software update gone bad, right? You think about that, the poor person or people responsible for that update, right? They push out an update on what's called endpoint detection software, and it affected the Microsoft systems around the world. Whether, Delta Airlines CEO just came out recently and said it cost them $500 million, right, because of canceled flights. So the worldwide impact of that is unbelievably widespread. And it's partly due to the nature of the product they had and the fact that it was so difficult to fix after the fact, right? Because it was a security feature. So I mentioned that because first of all, people need to understand there has never been a company, regardless of the size, that has not had some issue with a software update, right? How does that affect us in the dealer world? Well, think about, we've talked about this for years at NAD. Think about cars, right? Think about this happening in 2 or 3 years from now with a fleet of vehicles, right? They're getting software updates. God forbid it happens, but we don't want to, some large manufacturer with their entire fleet bricked, right? I mean, that's a real issue that could happen in the dealership world, and our dealers ready to address that as a consumer, a service issue should it arise. So there's a lot of issues industry wide that has an impact on, I would argue, but thankfully it had a little bit less of a direct impact, at least on dealer specific systems, as you said, vendors. Now, there's that, right? And there's also the overarching question of, you're always going to get pushback from people saying, that's why we need to keep third parties out of these systems, right? I mean, there's sort of a like I said, a pendulum that goes back and forth. We have to protect this ourselves. We have to let the best in class come in there and work on these things. CDK is a slightly different issue. I'll bring back the aperture a little bit. I think a couple things that we're hearing from dealers and that certainly we're talking about. One, the easy stuff is sort of, do you have a business continuity plan? You should be putting it in place now. We're trying to give some dealers some tools to do that.
Well, yeah, what does that even mean? Like for someone, what does business
it means that you need to be practicing and ready for what the heck you're going to do if something like this happens again, right? So whether you're a CDK dealer or not, you should have a business continuity plan in place.
This episode is brought to you by OpenLane, the leading online dealer marketplace for used cars. OpenLane brings you exclusive inventory, simple transactions, and better outcomes, all with the lowest fees in the industry. Dealers love OpenLane because they can find a vast selection of off-lease exclusive vehicles, rental, dealer trades, and more, all combined with a truly transparent process, best-in-class inspections, and easy-to-read condition reports, allowing buyers to bid with confidence. If you're new to OpenLane, you can sign up now and receive a $350 buy fee credit. Learn more at openlane.com or click the link in the show notes below. Okay, so in light of all the events that happened to the industry in the last month and a half between, again, CDK, CrowdStrike, what do you say right now, and sitting in your position, what is the biggest security or regulatory risk dealerships are facing?
Yeah, I mean, security regulatory risk. There are always threats on the horizon. I think. Look, the easiest and most basic thing is you don't want a breach to happen in your store, right? I mean, that is the goal that you want to spend your staff's waking hours doing what they can to ensure, right? And it's easier said than done, right? I always use the example. There's a well-known bank that you would have known of that spends $250 million a year on cybersecurity, still had a breach, right? So there's almost no way to say that you can prevent 100% of the breaches, but you can do certain things to make your posture better, and obviously to ensure that if you do have an issue, you've got a defensible position because the lawsuits will follow, right?
And what are those things? What are those certain things?
Well, the first key thing is you got to make sure you're complying with the obligations you have under federal law. And the primary one there is the FTC safeguards rule, right? I've been talking about this both at NAD and ComplyAuto for years. People are probably sick of hearing about the safeguards rule, but it's critical, right? And I will tell you, I think dealers are doing a fantastic job overall, but there are still dealers that are not doing what they need to do on a basic level to be compliant with the safeguards rule.
Such as what? Can you give us an example?
Okay, so a little background on this rule is important. This rule is the federal statute that authorized this rule is called the Gramm-Leach-Bliley Act. That was actually passed in 1999. Okay, 25-year-old rule. Why are we talking about it today? Well, the safeguards rule came out a few years later. The FTC was directed by Congress to issue the safeguards rule, and basically it's a rule that says you have to take certain steps to protect this data that you get. Dealers are financial institutions under federal law. That is the Gramm-Leach-Bliley Act. A lot of dealers don't realize that. The first question they say is, why does this rule even apply to me, right? I mean, does the OEM have to worry about this? Do my vendors? No, it's the dealer. And the hook, the legal hook is because of what dealers do in terms of assisting and financing or leasing, they're a financial institution, right? So you're treated the same way as a bank or a credit union, basically, for purposes of this federal law. So dealers as financial institutions have to take steps to protect the data that they collect. Okay. And for 20 years, it was sort of take reasonable steps depending on what your size and the kind of information you have. Long story short, I could give you the whole background about why the change came into effect. The FTC issued an amended rule about a year ago that went into effect about a year ago that basically said, no, it's not just do what's reasonable. You got to do these 18, 20 different things. You have to encrypt your data at rest and in transit. You have to enact multi-factor authentication. You have to do penetration testing and endpoint detection. And you have to have a written programs. So there's a whole, frankly, complicated list of things that every dealer in this country has to do. And it's actually at the heart of what ComplyAuto does for dealers in many ways, is help them walk through those complicated issues. So that is, and here's the twist, and not the twist, the hard part, frankly, from a dealer perspective. Dealers can do a really good job of tightening up their ship internally, but one of their obligations under this law is also to ensure their vendors are doing the same thing. And that's been a big lift in the dealership space. Average dealer, I'm not going to be exact with this, but I know we looked at this 4 or 5 years ago. I've heard different numbers, between 25 and 40 different third parties they've got to share information with, right? Those are service providers. Those are people like your DMS, your CRM, your website vendors, whether it's, the service schedulers, whatever software providers you work with, and sometimes physical information, but usually software providers. There's a lot of them, right? And each of those third parties, for the dealer to meet their obligation, has to take those same steps to protect the data that as you are, right? And that's a big lift because, frankly, there may be some vendors that aren't doing enough, and they can't promise in a contract that they are if they're not doing the right thing. So that is the big lift from a dealer perspective. Make sure your internal house is in order. And then obviously make sure that your vendors are also doing the right things.
I want to pause on this for a second because I want to talk more about the CARS rule before we get into vendors and whatnot. So CARS rule is, anyone that has read about the CARS rule, it could fundamentally change the way cars are bought and sold. It severely impacts the car buying experience. Just some like anecdotes. As a dealer, you have to share the exact out the door price with the customer. If you're on a test drive, you have to give them the exact out-the-door price. I think we all know if you've ever sold a car, or even if you haven't, if you ever bought a car, you know that it's virtually impossible to have that price. It's just not how buying a car works, right? You have to get financing, and there's steps to the process. The first question for you, starting very high level, is the CARS rule going to happen? Yes or no?
Sure. And so let me give you the status, and it is sort of a confusing one. Usually they issue a rule, they tell you when you have to comply, and then you have to comply, right? What happened here is they issued the rule. They said when the date was, and this was so egregious that NADA, along with the Texas Auto Dealer Association, sued them. So the status is the court's thinking about this right now. They're going to listen to oral arguments from both lawyers in mid-October. What that means for a decision on the ultimate outcome of the rule is unclear. My guess would be sort of maybe around the start of next year, 1/1/25.
All right. So in theory, something could change within 6 months. In theory. All right. Explain to me like I'm a fifth grader. Like what could change? I show up to that dealership. Again, in theory, I know it's not going to be perfect, but like what's the range of possibilities on January 1st, 2025? When I enter that dealership, what am I doing differently potentially?
So let's say the NADA challenge doesn't succeed and the rule goes into effect. There are a sort of series of obligations, right? And it gets complicated. This is sort of a hard to explain in an elevator speech. But a couple of things that I think you hit on, the biggest change from a dealer perspective is understanding what the FTC would require you to disclose as a dealer in terms of offering price. And let's again, to simplify it, what the FTC doesn't like are doc fees and other fees that are not disclosed in the advertised price of the vehicle. What they don't like is a dealer saying this car's $35,000, and then you go into the dealership and even without taxes and anything else, it's $38,000 because of a fee that wasn't disclosed, a mandatory fee that wasn't disclosed in the advertised price. So that is probably at a fundamental level one of the biggest changes dealers would have to understand is they have to make sure their advertisements and their communications with consumers include this new offering price, which is as you said, an all in out the door price. Now, it could exclude taxes, and there's a whole bunch of exceptions always, and there's a distinction between mandatory add-ons and optional add-ons. So it gets complicated. But at the end of the day, you got to have a price that someone can walk in and pay $35,000 for, not $35,000 plus, right? So that is going to be a difference. And frankly, proving that and complying with what they've required dealers to do is going to be a lift. Right? How do you make sure you've got a record that you gave this person in your very first communication with them this offering price? Right? You can't even have a normal conversation with a person who comes in and says, "Hey, I like that Silverado right there. Is that eligible for the finance special?" And you can't say, "Oh yeah, let's take a look at it and talk about the features." No, your first communication has to say the offering price is $52,597, and that has to be documented somehow. And then you can have a normal human conversation, right? So it's just one of the many ways. The FTC doesn't get how this world works, and they're forcing these sort of square pegs and round holes from a dealer perspective. You're also going to have to stop anytime they talk about a monthly payment or a monthly payment comparison and give them a disclosure of the total of the payments. Or if the monthly payment's being compared, you have to give them another form. So all of these new forms and new disclosures that, again, ironically, the FTC says they did this to make the whole process go faster, which of course is nonsense.
Mm-hmm. Okay, so when is the next milestone with this cars rule? Like, when is the next decision being made? Or
again, oral arguments are in October, and then the court decides at some point after that. Right? They're under there's no deadline. So just a rough guess is probably, like I said, start of the year we'll have the Fifth Circuit decision. Now, does that mean that's the end? Could somebody appeal it to the Supreme Court? Maybe so. We'll see how that goes. But let's also level set in a few things. I think, so there's a chance that it will just come into effect as if, NADA loses the lawsuit, it comes into effect, and it'll come effect, I would think, pretty quickly, because the FTC is probably saying, look, you already waited 2 years, you knew this was coming, so you got 60 days or whatever. I'm just making that up. So there'll be some point early next year where dealers will just have to start being ready to comply with this, right? Or NADA could win, in which case it doesn't mean the FTC can't do anything. They just have to go back to the drawing board. So maybe you have to wait another year or two and the same rule comes out again, right? So that's another possibility. In the meantime, there are also other rules that they're seeking to pass, like the junk fee rule, which currently would not apply to dealers because of the cars rule. But if the cars rule goes away, then all of a sudden you got to worry about the junk fee rule. So it gets confusing, but here's my bottom line for dealers. There's going to be something in this area that is going to require you to at least understand, probably adapt at least your advertising practices, and most likely the disclosures you give to consumers. So understanding at least basically what they're getting at, and probably having some training in place now for your staff, because I'll tell you the other big sea change is, in my mind, is that, dealers are used to, as you said, in your experience as a dealer, you're used to the alphabet soup of requirements, to giving all these disclosures and forms, and the deal jacket gets huge because of all the stuff the government makes you do. But that's historically been confined to the F&I office, right? You train the F&I folks for a reason, because they know this stuff. They can comply with it on behalf of your dealership. One thing the cars rule does is sort of expand that obligation to everybody in the store, right? So even if they come and ask the receptionist about a car, you've got to have a document showing that your first communication was X, right? So that's, to me, that's one of the biggest problems with the rule, is it's going to make it such an artificial interaction from the consumer's perspective, potentially, at a dealership, right? I mean, people want to help consumers at the dealership, and you may be constrained. Say, I'm sorry, I wish I could help you, but I need you to talk to, and funnel them over to someone who's trained on how to do it the right way.
So I want to zoom out now. Talk to me about, what are the costliest mistakes that dealers are making? Like, if you had to stack rank it, like, what are those top 3 that you're seeing? Costliest mistakes from compliance, regulatory, just what are those 3 things?
Yeah, and I think the way to address that is to say, where's the biggest potential financial risk in terms of your
where's the biggest potential, but also realistically, right? Like, I had massive, as a dealer, right? I had massive potential risk with, financing and making sure that, we're getting the exact information and, selling to thousands of customers a year. But that was something that we did very, very tightly. And, we avoided the financial risk there. Whereas, if there was oil on the floor in the shop that wasn't properly cleaned up, and I'm giving you like a stupid example, but you get what I'm trying to say. Like I'm trying to, I want to bridge the gap of like potential, but also, real.
Yeah, right. It's a great point, and I think it is funny because there is an inherent tension between compliance and profitability. Sometimes there just is, right? I mean, if you take shortcuts, sometimes you can make more money, right? And that's just the reality. I get it. We can talk about one specific issue when we talk about some of the things happening in the website world about a very clear sort of tension that exists there. But to me, I'm actually going to go back to one that's a little bit older and a little bit under the radar, because I think this is a sleeper, huge financial issue for dealers, and that's red flags. So there are requirements under federal law to basically verify the identity of someone that you're going to extend credit to. That's a vast oversimplification, but that's essentially what you have to do. And the reality is that's one where this aligns, because being compliant with that rule is going to stop identity thieves from basically stealing cars from you. And I've talked to dealers, mid-sized dealers, that lose over $1 million a year to identity theft, right? Because as most of you know, the contract's going to come back on you as the dealer, and you're stuck with the bad deal when the finance company kicks it back to you because there was an identity thief involved. So that to me is sort of low-hanging fruits, or something that dealers could probably tighten up easily and save them money today, right? I obviously, the data security and privacy, the breach notice is a real cost, and is happening today. I mean, CDK aside, there was a large dealer group in the West Coast that had a direct hack themselves. That they were down. This ransomware events happen, unfortunately, routinely with dealers, and these are real hard costs the dealers have to face today. So I do put that in my top tier of triage, right? I used to tell dealers 2 or 3 years ago that TCPA, text messaging and communicating with their customers, was probably in the top tier. But there's been a Supreme Court case that sort of took a little bit of the pressure off that, because basically the plaintiffs' lawyers, some of their theories were blown out the door. So I'm not, that's still in the top 5, but it's the pressure on that's come down a little bit. Text messaging still has some inherent risks. And the reason is because there's statutory damages. Anytime you have in other words, if you have a law that says you break it, you get X dollars per violation, that's going to attract plaintiffs' lawyers like flies to honey, right? So that is why.
It's cumulative.
But it's cumulative, right? I mean, and in the TCPA case, it was $1,500 per call or text, right? And so it's very easy as a plaintiff's lawyer to come and say, you did this wrong. I multiplied however many text messages you sent by $1,500, pay me $2 million, right? So that was a real problem for a long time. Still is a problem. It's become a little bit better because of some of the rules and some of the policies that have been put in place at dealerships. But that, I've said for a long time, to bring this down to the dealer world, that's one of the many reasons you got to make sure you understand what your salespeople are doing with their personal phones with consumers, right? I mean, let's bring this to the real world. People communicate on their phone all the time, right? Salespeople are human. They do things the way that everybody wants to do things. Dealers have to really think about the risks and the potential liabilities that could bring to you as a dealer. Having that unfettered, you got to get controls over that. You have to have records to show you what you're going to do, because there still are some risks out there from those communications, especially marketing communications. And then I guess I would also put, only because it's so topical and it's a really under the radar issue, is some of these what they call wiretapping lawsuits that are hitting this is a very underreported issue that a lot of folks out there may know about, that we are seeing every day affect dealers, OEMs, finance companies, and others. And we can get into what that means later. But those are sort of, if I'm doing triage, those are sort of my top 2 or 3 from a pure financial perspective today for dealers.
This episode is brought to you by my very own Car Dealership Guy News. CDG News is here to help you stay updated on all things automotive. We're not your typical news crew. We're bringing you concise, unbiased car industry news in easy to digest formats. From the hottest headlines to podcast summaries, dealership best practices, and industry insights, we've got it all covered. And guess what? It's all free, no paywalls, just like we always promise. Hop over to cdg.news, that's cdg.news, and check us out. We're all ears for your feedback. Tell us what you need. Give us your honest thoughts. We're here to deliver real value. So don't wait. Head to cdg.news now or click the link in the show notes below. What about like quick wins? Right. There's a lot of things that, like you said, changing moving from a vendor to another one that maybe, is more compliant because, it protects your customer from it. Like that's a process, right? But like, are there any quick wins, whether it's like some form of training with your teams? Like if someone is listening and they're like, if you could leave them right now with one quick win that they could go to the dealership and implement pretty seamlessly, privacy policy. I mean, I don't even know what.
Well, at the risk of a little self interest, it's in the cookie consent banner world. So let me explain this issue because it's one that people have to understand. I will tell you this: I actually have seen a lot more demand letters and lawsuits in this area than anywhere else, and I'll tell you why. Remember what I said earlier? Statutory damages, right? So there are some. This is actually a sort of a new one to many people. It arises under state law, and of course, as many of these things, it comes out of California. And there's a California statute that has as much as $5,000 statutory damages. Okay. So this is going to sound odd if this is new to you, but there are plaintiffs' lawyers who are filing hundreds of these lawsuits saying that basically by implementing cookies, pixels, scripts on your website without the consent of the consumer, appropriate consent, that is wiretapping. Okay, so there's actually these wiretapping statutes on the books in California and Florida and some other states. And believe it or not, they've managed to commit some courts to say that act of loading these cookies and using the cookies without the consent of the consumer is wiretapping. So, quick win: get the right consent. Right. So we one of the things we provide to our customers is a banner that we've looked at all these cases. We've done a very thorough investigation of where it is. We have some customization you can do. There's geofencing by states. Lots of tools you can implement, but get the right banner on your website. I mean, it's as simple as that. You've seen these things on websites now, right? The thing that pops up that says, I accept or deny cookies.
It's the bane of my existence.
It is, and it's too bad because it's, again, this is just sort of the way the world's going. You try to make it as seamless as possible, but this is real, and it's not been in the press as much because, frankly, these are demand letters going out, and frankly, a lot of them get settled. If they get settled, you don't hear about it in the press. But just in the past 2 weeks, I would say there were another dozen or two filed against, including one large OEM, is a defendant, and a few other lenders in the auto space. And so they've hit the auto space hard. Again, quick wins. It's easy. Adopt a compliant consent. It can't be just anything. In fact, you can make it worse if you do a bad one. But get the right consent banner and get consent so you can prove you've done it. Because we found if you do that right, they move on to the next a website they're trying to sue. So,
talk to me a little bit about marketing and AI. There's a very big rise in AI chatbots. Lots of dealers are starting to implement chatbots, and in many cases, it's driving ROI, it's driving profitability, it's 24/7, right? I'm personally a fan of, several companies that offer this service. Talk to me about the issues that you foresee there, right? Because that's a whole new Pandora box, right?
It is. It is. I'm sorry. I was just going to say, yeah, it's a great question. I mean, the first thing to remember is what I just said. Make sure if that thing's loading as its own subdomain, or in a way, there's a lot of ways to get in trouble on your website. Think about what a chatbot obtains, right? I mean, people tell you all sorts of things in the chatbot. They can tell you their credit history and all sorts of sensitive information. So protect it. But the AI issue specifically, there's sort of two things the authorities to date are focused on. Okay. And certainly at the FTC level, and then there's also been some things come from the Biden administration and at least federally. And one is they are concerned about deception in the use of an AI tool. So this is sort of a weird one, but believe it or not, they care whether somebody thinks they're speaking with a human being or not, right? So it's a tricky one because I know these chatbots are often AI driven and they have a little person's face and it looks like you're speaking to someone, but try, at least think about clarifying that this is automated, because the FTC has expressed interest in that. They see it's deceptive, right? To have someone speaking to an AI tool that they think is a person. The bigger issue, I think, is the use of AI in two areas, and that's in employment or financing. And so obviously the employment space is not as relevant for dealers, but in terms of financing, that does become an issue for dealers. And the issue that the federal government is concerned about, they call it algorithmic bias. And what they say is, if you're making a decision using AI, and it affects either a financing offer or financing term, something like that, then you got to be able to prove what the basis of that algorithm was, right? So I'll give you an example. You've got it now. This is not necessarily a chatbot, but this is an AI tool that's popular in the dealership space. An AI tool that will say, we don't want to give our incentive dollars to just everybody who wants to buy an F-150. We want to target Brad Miller and Sue Smith to give these incentives to, right? Now, how did that algorithm behind the AI determine it was Brad Miller, Sue Smith, and not somebody else, right? And is there some sort of fair lending violation based on that? Is there some sort of disparate impact under federal law? There's a very big push. In fact, one of the FTC commissioners, I think I told you earlier, 5 commissioners, one of them was a former professor at Georgetown, and his specialty was algorithmic bias. That's like his big issue. So I tell you that because that is a real issue in our world, whether it's lending decisions, incentive decisions, anything that also involves a decision that's made affecting a price that you give to somebody, you're going to have to be ready, or at least your vendor's going to have to be ready to explain how that was determined. So those are the areas that they focused on. Now, your point on the chatbot, I think the communication piece, you've also going to have to worry about that. We got CARS rules implication that I could explain. So there's lots of regulatory implications of chatbots, but the two things that jump out at me are protecting that information, make sure you understand how that works within your website ecosystem. And 2, if it involves anything having to do with financing, you just have a higher level you have to worry about.
All right. So, Brad, we spoke a lot about the in-store operations, the DMS. Is there anything else regarding dealership websites? This is like the modern storefront for the dealer. Anything else on that point?
Yeah, exactly. You've transitioned to that exactly right. I mean, it's not, I've been around long enough to know it used to be just the DMS that the dealers were worried about. Who's accessing my data? Who owns the data? These are somewhat antiquated concepts, but now it's transitioned to the CRM. And then today, I think the biggest area of weakness for dealers, in my personal opinion, is your website. You would not. I would just encourage dealers to understand what's happening on your websites. I hear a lot of sort of pushback from dealers on, the level of OEM control on the advertising on the websites. But there's a whole back end to what's happening on your websites. If you go and look, you would be amazed at the cookies and the scripts and the pixels and the third parties that are taking information from your website and using it for purposes that are sometimes outside the scope of what they probably ought to be doing, right? Think about what's on your website. It's not only information about who's visiting your virtual storefront, but it could be credit applications. It could be all sorts of very sensitive and very relevant and very valuable information. And so again, it's just something a lot of dealers don't have an awareness of. It's in this technical realm where you kind of need a little bit of help. But I would just encourage dealers, in addition to the liability issues we talked about, in terms of website, these lawsuits. You just got to know what's going on with your website. That information is critical to running your store. So I would encourage dealers to stay on top of that if they can.
Hey, Brad, before we wrap up, all this regulation and compliance and, given we're in such a technological world, do you think that this is just going to hamper innovation for car buying? Like, are we just going to see the car buying experience? Well, let me preface that with we're already seeing the industry facing so many different forces, whether it be direct to consumer, right? Online upstarts. There's all these competing forces for the consumer, right? That's enough to have an impact on the experience. Now you're adding regulations, compliance. Do you think that ultimately this hampers innovation, or are you optimistic that we can, kind of evolve through it using technology and make the car buying experience actually better, not take 5 hours? Like, what's your outlook?
I have learned to never underestimate dealers. I'm telling you, it is going to get more complicated, but there are going to be some smart people out there who leverage technology to make it better. And I've learned in 20 plus years in this business that I will never underestimate dealers' ability to take lemons and turn into lemonade. I mean, there are ways to do that. I think as part of a professionalization of our industry, I think it could be viewed as a good thing. Data security is a good thing, right? I mean, there's some pain up front, but making consumers feel good about that kind of about their interaction with you is helpful. And I do think things will speed up. There's always bumps in the road. I think there'll be transitions. Doing it yourself may no longer be an option, but absolutely, I'm optimistic that dealers will take the requirements, turn them into a consumer benefit, and hopefully make the process even more professional, more pleasing from a consumer perspective, and give more to consumers. Now, again, they have to have the ability to do it. That's always the part that has been my number one dealer advocacy issue for so long. Is dealers are hamstrung. When the chains are taken off, dealers are able to do amazing things from a technology perspective. And so, hopefully, we can get those some of those restrictions removed, and dealers will be 1,000 flowers of competition. Will make things better.
Any closing thoughts? I mean, this is, you've shared a lot of really great knowledge here. And I'm already thinking about having to bring you on again to talk about, the update on the cars rule, kind of what changes in October, November, January. Can only imagine how topical this is going to be. Any closing thoughts before we wrap up?
Yeah, look, I think the closing thoughts are, it's been my job for 20 years to tell dealers about these regulatory regimes, and it can sound depressing and overwhelming, but there are people out there to help you. A, and B, it's not something you can't overcome. Dealers are doing it. Dealers are meeting the obligations and not hampering their ability to give a great customer experience and still be profitable. So I don't think in the long run that these will be more than small speed bumps for the dealers. That you have to focus on it for a little while. You got to make it a priority, a cultural issue at your store. But if you do those things, you're going to be ahead of the game. And frankly, I think in the long term, you'll come out on top, not just over these, whatever the states and the feds sort of layer on you, but also your competition. So I encourage you to do that and find the right people to partner with.
Well stated. Brad Miller from ComplyAuto. We'll throw up links in the show notes below if anyone wants to learn more about how you're working with dealers, how you're helping dealers out. Again, super impressive background at NEDA. You've spent lots of years in this industry, so you know a thing or two, to say the least. But I appreciate you coming on. This was extremely insightful, and we'll have to do it again.
Well, Yossi, thank you so much for having me, and anytime.
All right. Hope you enjoyed that episode. Please give the podcast a rating, consider subscribing to the show, and check the show notes for links to what we talked about. Thanks for tuning in. I'll see you guys next time.